Take your places for the event of the day. Just to let people know that there's dinner at 6 tonight at the Grace Darling Hotel, which is if you come out the building and walk straight up going south along Smith Street, after a couple of blocks you'll end up at the Grace Darling Hotel, right Meredith? Yeah, and if you want to put your name on the list outside just to be helpful, that would be good. It's pay as you go. And Wendy is now going to introduce our next speaker.
Well, I'm very happy to introduce Kevin Murphy. As you know, he's had long experience in native title claims. He worked for Cape York Land Council, but is also currently a consultant. So he's had experience both in a rep body and as a consultant, and has mainly done work in North Queensland. So welcome him to speak.
Thanks, Wendy. Before I begin, I would also like to make acknowledgement of the first people of this country on which we meet. I think it's always a political act to do so, but I think it's become even more important since the radical right-wing opposition raised the issue in the election campaign that they lost. So it's been remarked in several Federal Court native title judgments, commonly citing the full court's Al Yawr decision, that the word society does not appear in the Native Title Act. The entry of this concept into native title jurisprudence derives from the High Court's Yorta decision, of course. It finds its way from native title jurisprudence into anthropology via the questions that lawyers put to us in seeking expert opinions that they can use as evidence in court. In a 2023 judgment in relation to the islands of Waral and Ului in Torres Strait, Justice Mortimer, as the now Chief Justice then was, and I'm not sure what the legal etiquette is in relation to the title of the now Chief Justice. I'll refer to her as Justice Mortimer today because that's what she was at the time of the decisions I'm talking about. She referred to the concept of society as it applies to native title as a distraction. She wrote, "The term society is not found in the Native Title Act. For native title, it's a concept originating in the reasons for judgment in Yorta. Justice Finn made the same point in Akiba. It's revealing that many judges in this court, working at trial and appellate level in native title, are not enthusiastic about the concept in their published reasons. The concept tends to distract from the questions asked by the Native Title Act. The distraction is very much evident in the expert evidence in this case, being Waral and Ului." In the following paragraph, she went on to say, "The dominance and utility of this concept in native title law might well be open to question. So given this hint of an opening to questioning the dominance and utility of the concept as it's been applied in native title," and I'm not sure whether she intended that invitation to extend to anthropologists, but nevertheless, I'll take this opportunity to offer an anthropological perspective on the matter, and thanks to Julie and the CNCA for giving us the opportunity to do so. And as one of the anthropologists who gave expert evidence in the Waral and Ului trial, I take it that I'm among those implicated in the distraction that Justice Mortimer discerned. I do agree with Justice Mortimer to the extent that the concept of society, as it's deployed in the native title context, commonly creates a distraction from the main issues on which anthropologists are asked to give opinion evidence. I suspect we have differing diagnoses of why that might be. Today I'm going to give an overview of the context in which Justice Mortimer made the remarks that I've just quoted, being the Waral and Ului native title claim, and consider the way in which it manifested as a distraction. I will suggest that the logic of the native title definition of society involves a preconceived assumption that Australia was and is divided into a multitude of separate and discrete normative systems. I see this as implicit in Justice Brennan's Mabo judgment and in the Yorta Yorta plurality judgment from which the particular definition of society derives. And this is further elaborated in the Drury Full Court majority judgment. In my view, the presumption of such discrete and separate normative systems is not consistent with an anthropologically informed approach. In response to questions put to us by lawyers that to incorporate such a presumption, I'll go on to suggest that for anthropology to maintain integrity as a discipline, and therefore, incidentally, its usefulness to the courts, we should stick to the facts relating to the manner in which social distinctions are made and not be tempted to presume otherwise. So, if we place Wat Island Ului in the centre of a Google Earth image and zoom out at a broad scale, we can see it's located in Torres Strait, much closer to eastern Indonesia than it is to southern Australia. Zooming into a bathymetric image, we can see the shallow waters of Western Torres Strait and the northern end of the Great Barrier Reef to the east. Zooming in to the same image, those are the islands of Wat Island Ului, situated between Badu and Moa in the north and the Muralug group of islands to the south. The first native title claim over Wat Island Ului was filed in 1996 by Badu Islanders as part of a claim over Badu Island and numerous other uninhabited adjacent islands. This occurred following a 2-week event in June 1996 prior to the establishment of the native title rep body in the region, when 2 lawyers came to Thursday Island and obtained instructions to file dozens of land and sea claims over most of the islands and seas of Torres Strait. Shortly afterwards, Cowreg people of the Muralug group of islands contested the exclusive claim by the Badalgol over Wat Island Ului. Exclusive overlapping claims were also made by Badalgol and Muagol over the numerous other small uninhabited islands between Wat Island Ului to the south and Badu and Moa to the north, and by Cowreg people who filed their own claims over some but not all of the islands of the Muralug group in the south. Through a process of negotiation, the overlapping claims between Badu and Moa were resolved. Muagol people got a consent determination over their home island in 1999, Badalgol over their home island and other islands in 2004, and in 2006, the uninhabited islands that were exclusively Muagol, as well as several in which native title is jointly held by Badalgol and Muagol, were also determined by consent. All of the other inhabited islands in Torres Strait, apart from some in the Muralug group, were determined by consent in favour of a group defined in name by reference to the home island. For example, Sabaigol, the people of Sabai, Yamagol, the people of Yama, Erubamlay, the people of Erub, over the period between 1999 and 2004. By 2006, most but not quite all of the numerous uninhabited islands throughout Torres Strait were also determined by consent, with many of these being so-called shared islands, in which 2 or more of the neighbouring community island groups jointly hold native title, up to 5 groups in the case of Deliverance Island. Throughout that process of discussion, negotiation, agreement making over who the rightful people for each of the islands are, the question of what scale of social grouping was to be regarded as a society just did not arise. In the meantime, the multitude of overlapping sea claims throughout Torres Strait that had been filed by those 2 lawyers back in 1996 were withdrawn, and a single claim was filed over almost the whole region in 2001. The consultation process leading up to what was to be called the Torres Strait Regional Seas Claim, Cowreg people were involved and for a while vacillated between including their sea country in the Regional Seas Claim or going it alone, and in the end they decided on the latter course. Wat Island Ului was still in dispute at that time, and with Muagol and Badalgol people asserting their sea country extended southwards of Wat Island Ului, the outer boundary of the regional sea claim included those 2 islands, as you can see on that map. 2 Cowreg men joined as respondents to the Torres Strait Regional Sea Claim, and the Cowreg people filed an overlapping claim over the area around and including Wat Island and Ului. It was expected from the beginning that that claim would go to trial because commercial rights in the resources of the claim area were being claimed as native title rights, and the state and Commonwealth were expected to contest that claim. It was anticipated that the dispute over White Island Uluru would be addressed in the context of the sea claim going to trial. Gurungatakanu people from the northern peninsula area of Cape York also filed an overlapping claim over the southeastern part of the sea claim, and then once the matter was set down for trial and the judge, the late Justice Finn, became familiar with the various issues involved, he decided to split the claim into parts A and B, with B being the overlap areas which would not be dealt with in the trial. So much for the idea of resolving the dispute in the context of the trial. Excuse me. I was engaged to research and provide opinions focused primarily on the people of the Western Islands. Another anthropologist, Colin Scott, engaged to do the same for the Central and Eastern Islands, with Jeremy Beckett reviewing our reports and providing his own opinions on the basis of our reports as well as his own previous extensive research. Among the questions that were put to us in the terms of reference for our reports, which were drafted by Tom Keeley and others, was whether the claim group comprised one or more societies, with reference to the Yorta Yorta definition of society as normative system, and of course the quote commonly treated as definitional, the body of persons united in and by its acknowledgement and observance of a body of laws and customs. I considered the various scales of social grouping relevant to land and sea ownership in Torres Strait, focused primarily in the west, from the lineage to the clan, the island group to the island cluster group, with there being 4 cluster groups in Torres Strait approximating dialect and language distinctions, and the claim group as a whole. Stripped of all other considerations, each one could be regarded as, this is a series of ascending scales, each one could be recognised as a body of persons united in and by its acknowledgement and observance of a body of law and customs. But in my analysis, none could be reasonably regarded as a discrete and separate normative system, such as to lead to an opinion that there were several separate societies. My opinion was that, notwithstanding some variation in particular aspects of some laws and customs, the normative system of laws and customs extended through the whole of the claim group and beyond to both north, the adjacent Papua New Guinea mainland, and south, including Cowrie people and the adjacent Cape York Peninsula. Scott and Beckett came to the same conclusion, at least as far as Torres Strait and the Cowrie were concerned, although they were non-committal in relation to neighbouring Papuans and neighbouring mainland Australians. The State and Commonwealth contested this view. The State argued that there were 13 separate societies, there are 13 community islands in addition to the Cowrie people, and that native title rights extended only a short distance from each island, while the Commonwealth argued that there were 4 societies, each of the cluster groups, defined by reference to dense social networks, relatively dense social networks, and linguistic distinctions. The submissions of the lawyers for the claimants were that the court should find that the claimant group comprises one society, but if it found in an alternative that they were part of a larger regional society, including northern and southern neighbours, or that there were 13 or 4 or 2 or some other number, this shouldn't affect the ultimate outcome, which was, they said, that there is native title over the whole of the claim area. Having considered the evidence, Justice Finn wrote, the only reasonable rival contenders for the relevant society for Yorta Yorta purposes on the evidence before me are 1, Torres Strait Islanders who were inhabitants of Torres Strait its sovereignty, which may be found to include at least the Cowrie, and today descendants of those ancestors, or 2, the same persons then and now, but divided between Eastern Islands on the one hand and what Haddon called the Western and Central Islands, again including Cowrie in this will depend on the findings in Part B of the sea claim. I seem to have got a bit lost. Just ignore that for now. After, after noting that the question of whether laws and customs by which the claimants were asserting they derived their rights and interests were appropriately regarded as traditional laws and customs was a non-issue, which of course is why the whole concept of society was brought into jurisprudence in the first place, Justice Finn went on to conclude that the applicant has established its one society case. There is an irony in this. The issue of authorisation apart, the answers to the question of native title rights and interests, which is, after all, the concern of the Native Title Act, would in all probability be the same whether my conclusion had been 1 or 4 or 13 societies. So I think it's fair to conclude that Justice Finn might have regarded it as a bit of a distraction as well. Notably, the question of whether the Cowrie people were part of this same society was left open to be considered in the context of the anticipated Part B C claim. Justice Finn found that each island grouping holds exclusive rights within an area surrounded by its home and immediately adjacent islands, and there are shared overlap areas between islands, some of which include uninhabited islands, where there is jointly held or shared native title. However, on the grounds that the applicant had not made out its case for connection to some parts of the claim area, mostly at the extremities, he found that there's no native title claim in some parts of the claim area, as indicated in red on this map. There were no parts of the claim in which the whole claim group collectively were held to hold rights as a single grouping, and Justice Finn did not drill into the internal differentiation within each of the community groupings in his findings. He found that the claimants have a native title right to take and use the resources of the claim area for any purpose, consistent with the regulation of their own laws and customs, which included commercial purposes. He also made a distinction between descent-based and reciprocity-based rights, the former being recognisable as native title rights, the latter not. These findings went to appeal, eventually to the High Court in 2013, where Justice Finn's original findings were confirmed. There's a lot to get into with some of those issues, but I won't go into it today. The question of society didn't arise again. So this left Part B of the C claim and the islands of Wattle and Uluru still unresolved. In 2015, there was a court-supervised mediation process culminating in a meeting of Cowreg, Morgal and Bodelgal representatives, convened by a retired Supreme Court judge and a Federal Court registrar, at which unanimous agreement was reached in relation to both Wattle and Uluru and the surrounding seas, being the western overlap area of the C claim Part B. The agreement involved mutual recognition by all three groups that each of the others also held the same rights in the disputed area. After this court-supervised mediation in which this agreement was made, there was a delay of some 5 years as the TSRA Native Title Office became effectively dysfunctional. The details of that don't need to concern us today. Eventually, an authorisation meeting was held in 2020, with the respective lawyers given instructions to bring the 2015 agreement into effect. Shortly afterwards, a group of 5 Bodelgal men objected to the authorisation and made their objections known to the court. Justice Mortimer decided to bring the matter on for trial. I was one of 3 expert witnesses engaged by the applicant to provide opinions. Mine focused on Bardu, the other 2 respectively on Morgal and Cowreg. The Bardu respondents, those 5 individuals, and the state also engaged anthropologists, although after receiving a draft report, the state decided not to submit his evidence or call him as a witness. From the beginning, the state objected to the notion that Cowreg people are part of the same society as Justice Finn had found exists in the rest of Torres Strait. Thus, the evidence elicited in the trial was again framed around the question of the extent of the relevant society. At this point, I think I should just say something briefly about the unique colonial history that the Cowreg people have been subjected to. They're the only group in Torres Strait to have been physically dispossessed of their home islands, which includes Thursday Island, where the administrative centre has been located since the 1870s and still is today. In 1922, they were removed at gunpoint from Kirriri, Hammond Island, to Moa to make way for a Catholic mission. After World War II, some of them made their way back to their home islands, but with the ongoing operation of the state's protection regime, they were not allowed to live on Thursday Island, the town, and instead lived at Horn Island, where there had been an Air Force base during the war and where the airport still is today. As other islands in Torres Strait progressively gained greater autonomy in managing their own affairs on the outer islands, the Carrig people effectively existed as fringe dwellers on the margins of Thursday Island. There had been a long and close relationship between Carrig and Moalgal people, but the extent of intermarriage between the two groups during this period of Carrig residence at Moa increased still further, such that there are now very few people from either group who cannot trace ancestry to both. Also significant that as well as the close relationship between Carrig and Moalgal people, there had been long-standing connections of Carrig people with the mainlanders to their south, particularly with the Gurung people of Muri, Mount Adolphus Island, and the adjacent mainland, with many intermarriages and thus lines of descent connecting them up to the present day. So Carrig people are betwixt and between what's come to be ethnic categories of Torres Strait Islanders and Aboriginal people. This distinction deriving from a complex racialised colonial hierarchy in which Torres Strait Islander emerged as a distinct identity in the late 19th century. Many Carrig people now self-identify as Aboriginal and classify the Carrig people collectively as Aboriginal in contradistinction to Torres Strait Islander. Although there are others who reject the categorical opposition, and in the relatively recent emergence of the discourse of First Nation, this position, rejecting the distinction, has become more common. The Carrig sense of a distinctive identity, at least since the late 1990s when I first encountered them, has been centrally concerned with the mythology of Walban. Walban is a hero figure who moved north from the mainland, which is related today to the identification of Carrig people with Aboriginal rather than Islander identities, performed various deeds in which features of the landscape were transformed, and in one episode fought with Pitulai, banishing him to take form as a large rock on the southern end of Waral. This myth also features significantly, obviously, in their claim to hold rights in Waral and Ului. I'm going to skip a little bit. I'm going to skip a bit which basically says the form and structure of the Walban story is consistent with other mythology through Cape York into Torres Strait and into the southern parts of Papua New Guinea. The state seized on this aspect of the Carrig evidence to argue that it supported their view that Carrig and Torres Strait Islanders were two separate societies. They drew a categorical distinction between myth-based rights asserted by Carrig and occupation and use-based rights as asserted by Moalgal and Budalgal, which was consistent with Justice Finn's characterisation in the Torres Strait Regional Sea Claim. In the Akiba judgment, Justice Finn wrote, "Unlike mainland Aboriginal cases," I'm just extracting from there, "there is little in the laws and customs relied upon that has any informing spiritual dimension at all. Much appears simply utilitarian, much seems prosaic. As Mr. Harley QC, the barrister for the state in that claim, put it, the absence of the spiritual element is almost probably unique to this case." My own view is that distinction is overdrawn, that these are not categorical differences but rather varying emphases. The particular elaboration of the Walban story in the colonial and post-colonial context is crucial to understanding it from an anthropological perspective. And I am mindful that a judge can only ever make a decision based on the evidence before him, and the context in which Justice Finn made his decision was highly focused on the question of commercial rights. Now, in the Wat Island Uluru trial, Justice Mortimer was critical of my evidence on this point, that these are not categorical differences, but varying emphases. As she noted, my opinion had changed over time in my reports going back to 2008, in which I had, to quote her, provided a differently emphasised opinion about the role of the Walban myth in the establishment of the Cowrag people's connections to lands. That's not the only thing she was critical of me about. I won't go into all of them. Contrary to my opinion, Justice Mortimer found that the evidence establishes it is more likely than not that the asserted traditional source of Cowrag native title in Wat Isle and Uluru is the Walban narrative. Specifically for Wat Isle, that part of it concerning Pitalai. For Uluru, there is some reliance on the part of the Walban narrative concerning Walban's wives, evidence about which was very thin indeed. I find the evidence establishes on the balance of probabilities, contrary to the more contemporary accounts by the applicant's experts and by the applicant's arguments, that the Walban narrative is the normative rule for how the Cowrag people justify their native title claim over these two islands. Ultimately, Justice Mortimer found that the evidence did not support a finding that the Cowrag people hold rights and interests in Wat Isle and Uluru, neither on the basis of occupation laws and customs, as the lawyers had argued, nor on the basis of the Walban narrative, which she says was the correct basis on which they were asserting it. There was some contention over which of two stones was Pitalai at the southern extremity of Wat Isle. She didn't regard that as particularly significant, to her credit. But the assertions by some Moalgol and Bardalgol witnesses that Pitalai being located on the southern extremity of Wat Isle indicates that Cowrag connections extend no further north than that appears to have been important in her reasoning. Which is to say, this stone marks the boundary, it's on the southern end of Wat Isle, you've got no connections north of there by your own logic of your own mythology. This finding then affects Justice Mortimer's consideration of the question of society. She writes, if I'd been persuaded that first it's more likely than not the Cowrag people had rights and interests in Wat Isle and Uluru, or one of them, under traditional law and custom, then I accept it may have been necessary to at least go some way towards a broader finding about whether the normative system under which those rights and interests arise was the same normative system as that shared by Bardalgol and Moalgol as explained in Archibar. Since I'm not persuaded of the first contention, it's not necessary for the court to go further than identify what I consider the evidence demonstrates is the basis alleged for the putative rights and interests of Cowrag people in Wat Isle and Uluru, and make findings about what the applicant has or has not proved by the evidence. Incidentally, the judge did find in favour of both Bardalgol and Moalgol holding rights in Wat Isle and Uluru, and a determination to that effect was made last year. So it appears that although the society issue turned out to be a distraction in the Wat Isle and Uluru trial, it may have been less so if the findings of fact had been different. If the evidence had demonstrated to the judge's satisfaction that Cowrag people hold rights in the claim area by virtue of what was regarded as categorically different law and custom, with the basis of it being the Walban mythology. This would have had consequences for another question on which Justice Mortimer held that she did not need to make findings, being the question of whether members of two separate societies can collectively hold exclusive possession over the same land. It was an answer in the negative that the state was seeking in this trial, and in doing so it referred to the full court's decision in the Drury appeal. The majority judgment in that decision, made by Justices Mortimer and Colvin, elaborate on Justice Brennan's concept of communal titles, but within which subgroups may hold particular rights to particular places which are, quote, dependent on a communal native title. The logic appears to be explained as follows. There is a coherent and collective character to native title which derives from a common physical and spiritual connection manifested in the acknowledgement of laws and the observance of customs by the members of a society who share that connection. Therefore, it may be expected that usually there will be a necessary and direct correlation between the extent of the common connection and the extent of the native title. However, it may be the case that the common laws and customs, as observed by a society, have a character that means that it is inapt to treat all members of the society as possessing a particular right or interest in all parts of the land with respect to which they share a common connection. In such cases, even the extent of communally possessed rights and interests may be confined to particular individuals or groups with no overarching communal possession pertaining to all members of the society. Nevertheless, the title remains a communal native title that is an incident of a common connection of all members of the society observing the body of laws and customs from which the native title is derived. The judge's quote from Justice Brennan's Mabo judgment, in which he refers to an identifiable community living under laws and customs holding a communal title, notwithstanding that there may be subgroups holding rights within it. Justices Mortimer and Colvin also quote from the full court decision in Aliwar. The claim group or community has its ancestral source in the community which occupied the claim area at the time of sovereignty. And they go on to describe several aspects of law and custom that were held in common by the constituent groupings within the Aliwar claim group. They state in reference to that decision, it was emphasised that the laws and customs from which native title rights and interests derive their existence must necessarily be those of a society or group. Nevertheless, the decision recognised the following two possibilities depending on the nature of the society said to be the repository of the traditional laws and customs giving rise to the native title rights and interests. 1, the members of the community identified as a relevant society may enjoy communal ownership of the native title rights and interests, albeit they are allocated intramurally to particular families and clans. 2, the members of the relevant society may be dispersed in groups over a large and arid or semi-arid area, such that an inference of communal ownership by all members of the society may be difficult if not impossible to draw, in which case a determination may be made in favour of individuals or small groups who held native title rights under traditional laws of a society of which they are part. Notably, the Aliwar claim involved a claim group defined by reference to 7 landholding groups, clans, identified with 4 languages, only over part of each of those 4 language groupings, which each also was constituted by various other claims. As Justice Mortimer notes by way of quotation from that judgment in her Waral and Ului judgment, society is a conceptual tool for use in the Native Title Act's application. It does not introduce into the judgments required by the Native Title Act technical, jurisprudential or social scientific criteria for the classification of groups or aggregations of people as societies. The introduction of such elements would potentially involve the application of criteria for the determination of native title rights and interests foreign to the language of the Native Title Act and confining its application in a way not warranted by its language or stated purposes. These are, in my view, wise words. They appear to be at odds with the presumption that there are, as a matter of fact, a multitude of separate and discrete societies. As Ian Keane wrote, it may be that people in some regions did form themselves into more or less clearly defined ethnic groups and constitute bodies of practice which united them and which differentiated them from their neighbours, but we should look for evidence of such a pattern, not assume it a priori. Peter Sutton has analysed the issue of what he calls varying levels of resolution of traditional Aboriginal social groupings. He finds a structural tension between atomism and collectivism and argues that the distinction between local and regional is relative. Small populations, defined on whatever grounds, combine in a bewildering range, this is quoting Sutton, of ways depending on context. The distinction between local and regional is most useful as a relative one. The scope of some entity or other can be described as more local or more regional than that of another without too much fear of contradiction, except for the odd close call. He goes on, that's the end of that quote, he goes on to argue that traditional systems of Aboriginal land tenure involve a dual structure by which relatively small groups hold proximate entitlements to relatively small areas of land. We're all familiar with Sutton's argument. But these are embedded in a regional, dual and cultural system, which he says holds an underlying title. When it comes to specifying the extent of the regional system, Sutton concedes the task is something of a minefield. He states his agreement with Ian Keane that neatly, quote, neatly bounded collective social universes in Australia, Aboriginal Australia, do not exist. But then Sutton implies that there were in fact boundaries between discrete systems. Sometimes the differences between systems made them more distinct, sometimes less, and relationships between participants in the separate systems were and are, quote, managed through the bicultural skills of those living along the edges of such differing systems. But despite these inferred boundaries around discrete systems, however, quote, lacking in neatness of boundaries or agreement on their status may be, Sutton acknowledges that the wider dual publics, which constitute regional systems of law and custom in his terminology, are, quote, recruited differentially to adjudge particular events or contests and are thus context-dependent aggregate structures. Okay. I think you get the point. You're familiar with the literature. Quote Ian Keane again. Australia was not divided into a mosaic of separate societies before 1788, as the maps of Aboriginal tribes imply. People engaged in networks of interaction both within the continent and across its boundaries in the north. I'm skipping right to the end. The significance of these considerations for the question of how a normative system should be anthropologically apprehended is the importance of context. In my anthropological view, the native title claim process constructs a particular context, and it assumes that societies, as separate and discrete normative systems, are objective phenomena out there in the world awaiting discovery by a keen-eyed observer. This is not the case. And what do we do about it when we're given questions by lawyers that imply these assumptions that I've been referring to? A glib assertion that I do not accept the premise of your question is not going to cut it. And I hope you don't take what I've said today to be an expanded version of that. But I think it is reasonable to resist an unfounded assumption with an explanation of resist by giving an explanation of social differentiation as it relates to the distribution of rights and interests in country, and leave it to the lawyers and judges to apply the law as they may do. Thank you.
Thank you very much, Kevin. I thought that was a terrific example of an assumed collectivism, but also showing atomism by a particular example of this group challenging that view. And I guess one of the questions I'll start off with is what prompted them to really go down that path? Oh, sorry.
What prompted who to go down which path?
A challenge to the collective identity, I guess.
The five individuals?
Yes.
Yes, right. It gets down to particulars. So there's one guy who grew up in Bardu, moved down to Cairns for a couple of decades, had not been involved in any native title activities for that time, moved back to the islands just as the authorisation meeting was about to happen, and was a hot-headed young guy and managed to swing a couple of influential older men to say, we've got to stand up for our rights. We can't share it. And that was kind of a catalyst for these five to break away. They remain socially isolated to this day. There's a lot of tension in the community as a consequence. Yeah.
Questions?
Hi, this is more of a sort of an observation. There's obviously a lot of parallel, and I agree with your position.
Yeah, I was just saying to Petronella we should have swapped notes beforehand, but anyway.
But it just occurs to me, listening to your examples, that when you get with the states and the opposition, etc., but also anthropologists who are advising the states, who are reading your reports or whatever, people turn into splitters instead of lumpers, and they focus on these statements about boundaries and containers, and they go to this kind of, classical kind of set model rather than thinking about enchained, overlapping groups and how the real world is. Would you agree?
I partially agree. Not everybody does. I mentioned the anthropologist who was engaged by the state, who provided a draft report to them, and who told me that he was in general agreement with the basic thrust of my opinions and those of the other two, and the report he didn't get asked to finish his finalised report, didn't see him again.
Yeah, thanks, Kevin. That was really good. Just talking about that, we were hearing this morning about how the lawyers should, direct us towards questions that the court would find useful, and maybe have a say in the kinds of source material we should be considering as legitimate or not or illegitimate. I won't go into that, but I suppose it does raise the question that, on the one hand we're talking about being sort of faithful to the anthropological research and the traditions and the concepts that we're using, and often what we don't acknowledge is that it's used in a legal system that doesn't really have to take any of those things into account. So I would just ask what your thoughts on the capacity of lawyers and the court, lawyers to ignore evidence presented by anthropologists to them when asked those questions.
Oh, again, it's variable from lawyer to lawyer. To generalise, quite massive capacity to ignore anthropologists. We're there at their convenience. So, and most honest lawyers will say that we're there as a resource for them to use to generate evidence that they can use to assist their client's case. And that's the situation we're in. That's what Justice O'Brien was talking about this morning, that we're just expert witnesses in a legal proceeding. And to the extent that we're useful to lawyers, they'll keep us. To the extent that we're not, they won't use us. That's just the nature of the beast.
Thanks, Kevin. And thank you, Petronella, as well, for the somewhat related topic. I'm glad they were side by side. I have a little bit of a self-interest, curious question I wanted to ask just about this cultural block and society thing. At the moment, working for Wurundjeri, I'm looking at the applicability of this concept to how it's Kulin Nation for Central Victoria. And the different language groups that come under that category, or could come under that category, they have very different historical trajectories, and there's different levels of knowledge and different kinds of knowledge in different groups today. So I'm just curious about, and maybe more of a legal question, about the utility of that concept for a group drawing upon evidence from a different group, but because they're under that same rubric, it's therefore admissible or relevant, or is it not relevant? That's pretty broad question, but can you just comment on that, if I've made sense?
Yeah, I mean, I think cultural blocks can get you out of a bind when you're somewhere in the middle of one, but when you're on the edge, then the boundaries are going to move. So they're not fixed, just as smaller scale societies' boundaries are not fixed. So they can be convenient, and that's how I think some cultural blocks have been used by lawyers and accepted by the state, because the Rose is a pretty good case in point, I think. That one didn't work quite so well, though. So I think to the extent that you are assuming that there are bounded entities out there that are not dependent on the context of their elicitation, then you're going to run into the same issues. The extent of the normative system relevant to this particular group of people in any direction, north, south, east and west, will shift if you shift the focus of your attention.
Yeah, thank you. I think that's quite useful to think about in the Victorian context. A lot of the data that we have on the Kulin Nation is from a single person and his perspective, and his group's bang in the middle of the Kulin Nation. So that's not surprising, perhaps, that it's come out that way. Yeah, thanks.
Are there any other questions? If not, then I think we'll round it up and thank Kevin very much, as well as Petronella, for this session.
Thank you. And I don't have a message. That's the end of the day, isn't it? Someone's going to...
Just to say, see you all tomorrow at 9, and those who would like to go to the pub and those who'd like to go to dinner, head south to the Grace Darling.